In this lesson, what we're going to do is spend some time talking about the ways in which a company constitution can be altered, the way it can be changed, the way it can be reformed in a way that can essentially allow for as I mentioned, alterations here, or modifications could be another way in which we define it. There are various processes by which this can be seen and can be done and take place. This lesson is going to talk about a few of them. So the first thing is that a company can amend their articles of association by simply passing what is known as a special resolution. A special resolution requires a supermajority within a shareholding group of shareholders, essentially, so 75% or more shareholders can lead to a special resolution. This is a common way for companies to update their constitution. And what it essentially does is it allows for reflecting the changes of business operations, reflecting changes in share structure, reflecting changes in the needs of governance for the particular company. There might be situations and circumstances in which a company needs to make alterations to their basic structure and to their basic needs. This can be done through the alteration of a company constitution. In addition to this, shareholders may also enter into what are known as shareholder agreements. Now, a shareholder agreement is actually just a separate agreement that governs specific aspects of their relationship, the relationship that they have specifically with the company and their involvement. Now, this is something that takes place in a variety of circumstances. One which it might take is where you have a particularly large shareholder, where you have a particularly powerful shareholder that has quite a hands-on maybe approach to the company and to the business itself. They might want to have a specific shareholder agreement that is negotiated and is structured and is signed between the company and them specifically, rather than them being part of a sort of broader group of shareholders that would pass, for example, a special resolution instead. That can happen in various circumstances. While these agreements may supplement articles, one of the things that needs to be noted when it comes to shareholders' agreements and their sort of separate agreements here is that they cannot conflict with the statutory provisions or with the articles themselves. So that's less of an alteration of the articles of association. It's an alteration and modification of the company constitution to a degree, because you're essentially modifying the relationship that a shareholder has with a company, which can of course have a major effect on the internal affairs of that business operation, but it nevertheless does not pertain to altering the articles of associations themselves. And that makes sense. If you've got one shareholder that is having a negotiated shareholder agreement separate to everybody else with the company, that should not be enough to essentially be able to alter the articles of association for everybody. So that's one of the things that should be noted here. There is also something known as a special procedure requirement. To alter the articles of a constitution, a company must pass a special resolution. This requires a 75% majority of votes cast by shareholders entitled to vote at a general meeting. Shareholders must be given at least 14 days notice for generally when it comes to these kinds of agreements, and they also would probably need to have a detailed proposed changes of the resolution that is essentially being sought to be passed. The resolution must also clearly specify the changes to be made to the articles themselves. Vague or general resolutions would probably not be sufficient, and if the amendment is substantial, it may be advisable to provide a marked up version of the articles showing the changes. Some of these are sort of general practice, some of these are going to be more important when we talk about large corporations, large companies, large conglomerates, and would not necessarily apply in any meaningful sense to the smaller companies, the small companies or the micro entity companies as well. When it comes to changes to share capital, amendments related to this kind of nature will be particularly important. So, for example, things like things like, for example, creating new classes of shares, altering the rights attached to existing shares, changing the amount of share capital. These kind of changes may also involve new shares or consolidating shares as well, bringing shares together. When it comes to voting rights, changes can affect voting rights of shareholders. So, for example, the altering or the proportion of votes required for certain decisions, or creating classes of shares with different voting rights. This is one way in which an alteration can take place. Amendments of this kind of nature might also define, or should I say redefine, the process for appointing or removing directors of a company, the powers of the company, as well as their terms of office. Finally, as well, changes might also include procedures for board meetings, including what are known as quorum requirements. Quorum is just Latin, and it just refers to essentially enough that are present for a meeting to take place, and also the thresholds for being able to make particular votes. So those are the kinds of alterations that we can see when looking at a company constitution, and the earlier slides talked about the processes by which these alterations often will take place. What about the impact? Well, once the articles are amended and registered, the new articles bind the company, and they also, by extension, would bind the shareholders of that company. Shareholders are considered to have agreed to the new terms, even if they opposed them during the vote. So even if they oppose them during a vote, let's say there's only a 75% support of that vote. If that is the case, then those people who have decided to not sign on to them, or for whatever reason, or have disagreed with that alteration, they are still bound by that new change, because of course a company reflects a sort of collective decision-making process. So even if you are somebody who is in the minority when it comes to a particular agreement on altering an Articles of Association or a constitution more generally, you will still be bound to those decisions. If necessary, there might also be transitional provisions that are included within alterations. This might also address how existing agreements and arrangements will be affected by the changes. This will take place in often quite large situations, in quite big, like I said, conglomerate businesses, quite large enterprise companies, and will involve companies that might have already assigned agreements and contracts, maybe even shareholder agreements. So let's say you have a few shareholder agreements with different shareholders, and you decide to make an alteration. There's a special procedure that is done. A 75% vote for this change. There might have to be a transitional provision to sort of note the impact and make appropriate changes to the impact of that it has on each of these individual circumstances, those individual agreements that are had between the individual shareholders.